Hello, Trudy Brookman again of Trudy Brookman Attorneys. This is my third video in a series of 3 explaining how fluoroquinolone claims work. I'm answering a series of questions if you are trying to evaluate whether you would like to bring such a claim if you've been affected by a fluoroquinolone associated disability. And the question that I'd like to tackle now is, how does the process work and how much will it cost me? And how long will it take? Okay, let me start with the procedure because the other two depend on procedure. First step in the process is that our firm will gather basic information from you. We're going to try and work out which pharmaceutical company we need to sue and which doctors prescribed the fluoroquinolones to you, doctors or specialists, hospital, whoever is involved there. So we're going to be sending you a little questionnaire with a few questions that may involve you having to go back to your pharmacist and asking for the script again, a copy of the script, so that you can establish exactly what the brand name was of that antibiotic that you took and exactly when and how much of it was prescribed to you. You can also ask for those records from your doctor. Let us know if you have any trouble getting that from them, and we can do that part of the process for you as well. So first step, who manufactured the fluoroquinolones that you took and who prescribed those to you. And if there were quinolones that were prescribed along with cortisone, then we need to know who prescribed the cortisone to you as well. Okay, but we'll send you an email. Under cover of the email, there will be a list of questions also supplied to you with this basic information. So that's the first thing that we need to cover. The second thing is, what is the nature of the harm that you've suffered? And we know that the fluoroquinolone associated disability causes a wide range of different symptoms that can occur, go away, recur, never recur, occur after months and months of taking the antibiotics for the first time, even years later, as long as the first symptoms kicked in fairly shortly after you taking the first fluoroquinolone dosage, specifically a period of 2 hours from taking the medication for the first time, and then we're interested in any symptoms that first occurred until 18 months after the medication was stopped, and actually since then. Okay, so you'll see that we've got a list in which we set up all kinds of different symptoms that you can have from fluoroquinolones, and that we ask that you just tick on the list whatever you have experienced subsequent to taking the fluoroquinolones. Please don't be too critical about it. If you've ever experienced that since taking the fluoroquinolones, even if it was once, even if it was very light, even if it was of no consequence, tick the symptom for us, please. And then please add any that we may not have covered that you have experienced as well. If you're uncertain, rather tell us about it than leave it out, please. Okay, so that's the process of gathering the basic information. We expect that will take, well, it depends on you, doesn't it? So as soon as you have the list, however long it takes you to be able to gather that information and get it back to us, let's say 2 weeks. Okay. Second step in the process is the quantifying of the damages. In other words, putting a rand figure to the amount of harm and loss that you've suffered as a result of the fluoroquinolones. And as I've explained in the previous videos, we use experts to help us quantify that amount because we need the evidence to be able to back up yours and say, well, the nature of the harm that he or she has suffered is this. This is how long it is likely to continue into the future. This is the intensity of it. This is the level to which it has debilitated the patient. Okay, so that process, depending on how many experts we need to send you to, how long the expert takes before they can give you an appointment. Some of these experts are booked up. It's crazy. Some of them are booked up a year in advance, but I think that ours that we have in mind are not quite as busy as that. And we expect that would probably be a period of about 6 months between when we have the basic information from you until we have your medico-legal reports. And remember, we don't need to have every last one in place before we can submit your claim. We can always tweak things afterwards if we get one of the reports in a bit later. Okay, so that's the next step in the process. Then we would draft either a letter of demand or a summons, more likely a summons. So a summons is the first step in a court process where we taking the defendants to court. So we're summoning them to come to court and answer our claim. Okay, they can't ignore that. If they just ignore that, then we take a judgment against them immediately. That's wonderful. Would be great, but it's very unlikely to happen though. Okay, that they just ignore it. So a summons is a very serious way of saying, my client has this big claim against you. These are the details of the claim. Now answer. If you don't want to pay right up front, tell us why. Tell us how we're wrong about this claim. Okay, so the summons is generally there's a standard document that runs to about 5 pages, I think, and then there's the part which is called the particulars of claim, in which we set out the details of your case. We have a lovely example that we did for a previous client. It runs to about 28 or 30 pages, and we can reuse that example, which will make it much quicker and easier for us than trying to reinvent the wheel for each of you. So there are obviously similarities with everyone who has been affected by fluoroquinolones, but we'll adapt it so that it works exactly and reflects your story and your claim 100%. So that part of the process has to happen. It'll either be someone at our firm who drafts it, or our advocate. We're using an advocate called Wayne Coughlin at the moment, who is an expert in medico-legal matters and is wonderful. So between us, we'll draft a summons. That's a process that probably from the time that we have the information necessary to be able to populate the summons would take, I don't know, 2 weeks or a month, something like that, depending on how busy the advocate is, whether any of us are away on holiday or whatever. So I don't want to be bound by a month, but I expect probably quite a bit less than a month. Okay. Then once we've got the summons ready, it gets issued at the relevant court, and it depends on where your doctors and the pharmaceutical company is based. The last one that we did was here in Cape Town, so that makes it quite quick and fairly cheap, because we can go and have it issued at court ourselves. Otherwise, we would get another law firm to go and do that for you, and they charge us a small fee for that. Then after the summons has been issued, it needs to be delivered to the defendants, in other words, the pharmaceutical company and the doctors, by the sheriff of the court. And the sheriff charges money for that, so you can assume maybe 1,000 Rand in expenses for the sheriff to do that, and he often takes up to 3 weeks to go and deliver one summonses. Okay, so that's approximately how long that step in the process takes. Once we have had the summons served, we expect that we would get within a short period, a week or 2 weeks, a notice of intention to defend. So that's just a notice that's sent to us by the lawyers for the pharmaceutical company and the insurance company for the medical professionals. And then most likely a process of negotiation will start. Normally, medical disputes are settled by way of a confidential arbitration, and we can talk to you give you much more detail closer to the time. The alternative is to continue with a court process. That's slower, more expensive, and I would love to rather do the arbitration process if we can manage that. So I'm expecting that the pharmaceutical company would suggest that, in which case, unless you tell me not to do so, I'd like to accept that offer, and then we would have an arbitration, which is like a court case, except it's in a boardroom somewhere. We have a senior legal person who's not a judge sitting in the same place as the judge, and that person will make a decision after we've all submitted our evidence and our arguments in the matter. Okay, and then we would have the right to appeal that to court if we're unhappy with our outcome. Okay, so that really is the process. How long will it take? I'm giving you a really rough estimate, and you're not allowed to hold me to this because I don't have any crystal balls in my office. And life sometimes takes longer or shorter than you expect. But I'm thinking that this whole process can be finished in 8 to 10 months, maybe even quicker if we're lucky in the process and all the information comes flowing in a simple and quick way. What is the cost? Well, the cost is in a sense determined by the length of the procedure. So let's assume, let me try and give you the costs up to the stage just before we go to the arbitration or continue in court. I am expecting that the legal fees, in other words, our firm's fees, where we're spending many hours and we charge based on an hourly rate, would probably come to about 15,000 Rand, maybe another 5,000 Rand for the advocate. The specialist reports come in at about 10 to 15,000 per report, but we have a whole group of clients and I'm going to be asking for a discount. So if we send five people to one specialist, I'm going to be saying, oh, come on, your reports are going to be very similar for the 5. Give us a nice discount. So I'm going to try and negotiate that right down. So it'll depend. It'll depend on how many specialists you need to see, depending on the spread of your symptoms, right? And then how much I can negotiate the specialists down and what they wish to charge for their reports. But you need to budget that there would be a substantial charge for specialists' medico-legal reports as well. Okay. Then some money for disbursements, in other words, the charges of the sheriff to serve the summons on the pharmaceutical company and the medical professionals. Maybe 2,000 Rand at worst, maybe a few hundred Rand if it's just in Cape Town, and possibly some courier fees as well. So I'm thinking 2,000 Rand at worst for disbursements. Okay, where does that take us? I am happy to take the case on the following basis. If you are willing to give us an initial deposit of 10,000 Rand, and you're welcome to pay that deposit off as slowly as you like. 1,000 Rand a month. On the 10th month, we have the 10,000 Rand, and we start doing the work for you, and we put our heads down and finish it as fast as possible. Or if you're able, a lump sum of 10,000 Rand. So that's just the startup, so that we do have some money in the kitty to be able to pay out wherever we have to pay, for example, the advocate and the specialists and the sheriff. Okay. I obviously, once I've instructed them, our firm needs to pay them, so I need to know that there's a bit of money in the kitty. So the 10,000 Rand upfront deposit. Then I would like each person to pay a contribution of 5,000 Rand per month for a period of 10 months to cover the ongoing fees. And out of that, we hope that we would have sufficient money to cover the disbursements as well as we go along. So if you need lots of medical legal reports, then that should cover most of that as well. Let's see how it goes. We'll continuously communicate with you. The 5,000 Rand over a period of 10 months is intended to take you up to the stage where we can start with an arbitration and settle the matter on the basis that you get a substantial payout. So when we settle the matter, we will also be asking for a reimbursement of your full legal costs, so you should be able to recover that. Even if we don't manage to settle on the basis that your full costs are recovered, and I think we should be able to manage that, then we would get at least tax costs, which will cover you for between half and 2/3 of the legal fees. And in any event, you're going to be getting a big lump sum of money toward the end as well. So the legal costs, as I see them, would be a minimal portion of the claim that you will get in the end. I'm not asking for a percentage fee. We're just charging at our normal hourly rate, the way that we do all kinds of usual legal work. So I'm not trying to profiteer out of this. I'm not asking you for 10% of your settlement. That would be much more than the legal fees would be on the basis that we're intending to claim. We believe in the quinolones case, and we would like to pursue these cases for the group as a matter of principle, and because it's very exciting legal work if you're a consumer lawyer. We really believe in justice for consumers, and this is one of the prime cases in which we can use the Consumer Protection Act to really, really compensate people who have been horrifically treated by suppliers. So that's really how it is. The third question that I'm going to be asking you in the email that I send you with our questionnaire, remember I asked for the basic information, whom are we suing and what's the nature of your harm. The third thing that I would like to ask for is a commitment that you will stay the course. I know that it's stressful to bring a claim. The whole legal process is unknown and tricky, and all kinds of things that are unexpected can happen. You don't know, you've never had a lawyer before. It's terribly expensive. It's all of those things can play a role. I wonder whether I can ask you to think through those issues right up front, and to ask me any questions that come up. There is no such thing as a stupid question. I've also been the client of an attorney in my life. I had a car accident and had to claim against the Road Accident Fund, and I know what a vulnerable experience it is. You walk into the reception area and you think, shucks, am I paying for all of this? So I understand. Please just ask me your questions, and I want to ask you to ask the questions up front as well as you can, and as things go along. But I want to ask you for a commitment to stay the course and to not chicken out of this matter, and to finish the matter so that you can get a substantial claim paid out to you. So I want to ask for, as the third thing, just a commitment that you will continue with the case until it's finished. Thank you very much for your time. Please contact us, and I wish you all the very, very best with your claims, each of you. Thank you.